Hello, this is Dishha Bagchi for ThePrint, and we're back with Lieutenant General H.S. Panag to discuss his column from this week. Why did court-martial verdict fall apart in Amshipora encounter case? This was avoidable. Welcome back, General. Thank you for being here.
As I always say, it's a pleasure to discuss my column with you, Disha.
So in this week's column, you look at the 2020 Amshipora encounter case in Jammu and Kashmir. So to begin with, you argue that what's worse than the army committing human rights violations is that the failure of the legal system to prosecute and punish the perpetrators. And you believe that this is likely to happen in this case as well. So why do you think so?
See, as I mentioned in the opening lines, that only thing worse than the army committing human rights violations in an insurgency is the failure to prosecute and punish the perpetrators. Now, this was a high-profile case which took place on 18th of July 2020 and which was much lauded both by the commanding officer and by the brigade commander, and the army as a whole lauded it as a great operation in which 3 militants were killed. However, 20 days after the encounter, the case fell apart because it was found that rather than being an excellent encounter in which 3 terrorists were killed, it was the cold-blooded murder of 3 laborers who were lured in and killed. Captain Bhupendra Singh was found guilty earlier this year and sentenced to cashiering, that is dishonorable dismissal, and life imprisonment. On 9th November, the Armed Forces Tribunal, Delhi bench, suspended the sentence of life term and granted him bail. Primary observation of the Armed Forces Tribunal was that evidence accepted by the Summary General Court Martial was not convincing enough to hold the accused guilty of the charges. And the tribunal added that he's likely to be acquitted at the stage of when the appeal is heard in detail. Now, this is something which should not have happened. There was a requirement to prosecute and punish this individual, and it is not going to happen. It was a very high-profile case. In fact, the Prime Minister was seized of the problem. On 9th of October 2020, the Governor, Mr. Sinha, he personally went to Rajouri to meet the families of the laborers killed in the fake encounter, and he assured them, gave them the Prime Minister's assurance that justice would be done. And yet, the justice has not been done. That's why I raised the questions. Is there something wrong with the military justice system? Or are there vested interests that ensure that the prosecution is warped so that finally the accused can get away?
Right. So you talk about what could be some of the lapses. So what do you think was some of the reason that might have led the court to suspend Singh's life sentence and grant him bail? And what do you think were some of the lapses in this case?
In fact, the observations of the Armed Forces Tribunal were scathing. It said the findings, that is finding of guilty, was perverse and improper. Evidence was not considered in totality, and a selective approach was adopted. No motive was established for the fake encounter. The primary evidence relied upon was a statement of the accused himself at the court of inquiry while he was in custody. Now, court of inquiry is an inquiry, and it is not, whatever is stated there cannot be used as evidence in the court. It has to be corroborated by other evidence, and then primary witnesses have to be produced to corroborate the same. So the Armed Forces Tribunal held that this is violative of the Indian Evidence Act. There are some exceptions allowed under Section 27. That is when statements are made, but these have to lead to further evidence. They have to be proven. Similarly, the statement of Bilal Ahmed, who was the co-accused, I mean the civilian who allegedly helped the Captain Bhupendra Singh, it is also inadmissible. So if these were the prime witnesses, prime evidence on which the summary general court martial relied, so if they are inadmissible, so obviously the case would be thrown out. And another scathing observation was that the Armed Forces Tribunal said that the statement of the commanding officer was untrustworthy. No, the commanding officer apparently said that this was a standalone action which has taken place, and it is not, he was not aware of it. Now, the Armed Forces Tribunal has disbelieved this statement, implying thereby that it is unlikely that the CO was not aware of the case. He was probably aware of the case, and only this officer is eventually being victimized. Now, all this was avoidable on the 15th of October, soon after in October 2020, soon after the encounter, the details came out of the fake encounter. I had cautioned that this is a high-profile case, and the conduct of the court-martial should be done properly, and the investigation should be done properly to secure a conviction and to punish the individual. I had forewarned about this because there were other cases which I'll come to a little later. On 21 January 2021, that's again about 2.5 years ago, rather almost, I would say 3 years ago, I had again said in relation to another aspect which I was writing about. I said in this case, only Captain Bhupendra Singh is being charged, whereas the hierarchy in all likelihood was complicit. It is unbelievable in the Indian Army that an operation is carried out and the CO is unaware of the circumstances of the encounter. Also, the higher commanders, they analyze every encounter. And with experience, it's quite clear whether it's a genuine encounter or it's a fake encounter. So I had highlighted this aspect, and I had recommended that action should have been taken against the commanding officer, against the brigade commander, and even against the GOC of the victor force. Because all of them had lauded this operation, celebrated this operation, and in the court-martial, everybody, the commanding officer took the plea that he was unaware of this case. Now, fundamentals of the Indian Evidence Act were disregarded. There's a judge advocate general who's part of the court-martial, He is the prosecutor. He's also the advisor to the court. He's a legally qualified officer. The court itself is not legally qualified. It consists of senior colleagues or senior officers who are senior to the accused. Now, how could he allow the violation, the fundamental, of fundamentals of the Indian Evidence Act to be violated? It is unbelievable. It is not the first case. This is not the first time it has happened. That's why it is a cause of concern. In 2010, there was the famous Machal case in which, again, 4 laborers, 4 ordinary people were killed on the line of control by a unit in cold blood, again, to probably gain rewards or whatever. And initially, the army supported them, denied the case. Later on, it came to light that this was a fake encounter. In 2014, they were finally the action was started, and they were court-martial was held, and they were punished with life imprisonment. The commanding officer and 4 other personnel were punished with life imprisonment. Now, this case again in 2017 was uh, uh, sort of the sentence was suspended, and they were granted bail by the Armed Forces Tribunal. I'm not aware what has happened after that because it's not in public domain. In all likelihood, they are likely to go scot-free. Before, there's an earlier case, in fact, the famous Dangari case, which took place in 1994. 18 years later, the armed forces and the Ministry of Defense, through the Attorney General or his representative in the Supreme Court, misled the Supreme Court to say that we will try this court by court-martial, whereas they legally knew that they could not try them by a court-martial because it was time-barred. There's a 3-year time bar in the army. They could have only been tried by a criminal court. Now, if that was not enough, they held the court-martial and punished one major general and I think 4 or 5 other personnel, again with life imprisonment. No, we do not know what has happened after the case, but since it was the court-martial itself was illegal, it was time-barred, so again they are likely to go scot-free. So that's why all this, such cases are a matter of concern, and the military justice system is in need of serious reforms.
Right. So now that we've kind of discussed some of the lapses, and you've also mentioned some examples, and the fact that the 2020 case wasn't the first one where there were such lapses seen. So what do you think are some urgent reforms the military justice system needs?
See, the Indian military justice system is the legacy of the British Indian Army. It was there in vogue, soon after the presidency armies took control of India by the beginning of 18th century. And but the Army Act was published in 1911. That is almost 112 years ago. Now, at the time of independence, we merely adapted this act with cosmetic changes. No major changes were made. Yeah. So we do not have independent investigation. We do not have independent prosecution. Our courts, that is the court-martial, the presiding officer and members are not legally qualified. They just rely upon their experience. So it's a 100-year-old system, over a 100-year-old system, which is fair in principle, but it has not kept pace with times. In almost all other armies, similar systems which are in vogue, including the British Army, they have been done away with, and new reform systems have been introduced. So the reforms which I recommend and which are well known, one is that there must be an independent agencies for investigation and prosecution. Now, you have seen, most of us have seen the famous Hollywood movie, A Few Good Men. It's a good example how the prosecution was absolutely independent. He was not influenced by the command influence, as it can happen in the Indian Army, because investigations, prosecution in the court consists of officers who are senior to the accused, and they are susceptible to command influence being exercised over them, directly or indirectly. So one is the independent investigation and prosecution agency. I recommend that the Corps of Military Police and its equivalents in the Army and the Navy, these should be suitably reorganized to fulfill these two functions. then we require standing courts with legally qualified, officers. In any case, judges have to be legally qualified, so to man them. Now, they can either be from within the service, or they can be absolutely independent. They can be appointed, through the good offices of the Supreme Court or the High Court by a government order. Judges can be permanently appointed. Who should preside over the court martial? So there is these are the fundamental reforms, and these have been introduced both in the present day British Army as well as in the United States and most of the other modern armies. Our our military justice system has to be in consonance with the criminal justice system that prevails, and civil judicial scrutiny of anything done by the military justice system is the rule in a democracy. It cannot be done away with. And last but not the least, or before that, I also recommend that now the Army, the Navy, the Air Force have separate acts, that govern the administration of justice, and rules and regulations related to that. There is, now that we have the Chief of Defense Staff, he's got his own office in the Ministry of Defense. So there is a requirement of a common, act for the three services, so that the same principle applies to all the three services. And last but not the least, there is the requirement to educate the personnel across the board, the rank and the file, and the hierarchy, that it is a must to have independence of the judicial system and the investigation and prosecution. That there's a requirement to have it independent, so there is no kind of allegations that command influence can be sort of exercised over them. And the last point I make is that it must be understood by the military personnel also that the aim is not to secure conviction, but to ensure that justice is done. As is the old adage, that justice must not only be done, it must be seen to be done.
Right. Well, thank you, General. I think you brought up some great insights on, firstly, the Amshipora case, the complacency that might have been within the hierarchical system, what were some lapses within the case and the investigation and prosecution of the case, and what are some urgent reforms, as you mentioned, in our over 100-year military justice system. And I think you also gave us some interesting examples that our viewers might not have been aware about, in terms of what have been some other cases within this military justice system that have also experienced similar lapses. So thank you so much. For viewers interested in reading the full article by General Panag, the link to it will be in our description. Thank you, and we will see you next week.
Thank you, Disha. Always a pleasure.
Thank you, General.